Thanks, Bishop, and hello to everyone. I'm very happy to be with you today. In preparing my comments, I really struggled to try to anticipate what aspects of the bankruptcy process, particularly as applied to Catholic organizations, dioceses of religious orders, what would be the most interesting aspects of that process to the people attending this group. And I hope that I'll be able to touch on some of the things that are interesting to you. And if I've missed something, I'm welcoming your questions at the end of our session. And if there's something that you'd like to follow up on, please don't hesitate to contact me. I became interested in the sort of legal aspects, fascinating legal issues in Catholic bankruptcy cases a few years ago, in part because I'm a bankruptcy lawyer and a professor of bankruptcy law and other commercial law topics, but also because I'm a lifelong Catholic and am interested in the impact of this sort of unprecedented legal event in an institution that I care an awful lot about. And that's really the kind of genesis of my interest in the topic. What I thought I'd do today is talk about, explain some very basic ideas that are absolutely fundamental to kind of having a way of thinking or a frame of thinking about what a bankruptcy case might mean for a Catholic organization. First, let's start with a kind of a flyover, quick flyover of what happens in a bankruptcy case. And before we do that, I just wanted to explain that when I refer to bankruptcy, or when you hear about a diocese filing for protection, a bankruptcy case, it's seeking recourse to a federal law. Title 11 of the U.S. Code provides, it's a very long code, super long, provides for relief for debtors, both substantive law and an elaborate procedure whereby debtors can apply for relief in a federal bankruptcy court. And the process, of course, is federal, but what happens in a bankruptcy case depends on state law, a lot of state law relationships, debtor-creditor relationships, the claims, the legal basis of claims, for example, of sexual abuse claimants, they're all creatures of state law. And federal bankruptcy law respects those state law entitlements to an extent. Like any federal regime that coexists with state law, where bankruptcy law conflicts with state law, bankruptcy law is going to preempt state laws. That's because under the US Constitution, Congress reserved the power to make bankruptcy laws in Article 1 of our Constitution. So it's a federal state symphony, but bankruptcy law is going to preempt state law whenever they're in conflict. Important to remember that when an organization, a debtor, files for relief in bankruptcy, the world divides into two time periods: the pre-petition period and the post-petition period. So the filing of the petition marks the end of era number one and the beginning of era number two. And of course, that divide, that chasm, that demarcation in time becomes very familiar and comforting or comfortable to bankruptcy lawyers, but it can be odd to people who are thinking about a bankruptcy procedure who don't think about it all the time. Events that occurred, relationships that arose, liabilities that arose in the pre-petition period are going to be treated in one way, and those relationships, events, and liabilities that occur in the post-petition period are going to be treated under bankruptcy law in a different way. On the petition date, two very important things, legally important things happen. First is an injunction, a kind of universal and automatic stay or injunction of all litigation against the debtor. And we talk about a petition for relief in bankruptcy. That's mainly the relief that the debtor gets on the moment that their petition is stamped in the bankruptcy courthouse. Without any further process, all litigation in state courts and federal courts, any kind of collection activity against the debtor is enjoined. And that can be a tremendous advantage in just obtaining a little bit of breathing space to conduct the negotiations that are to follow in the context of a bankruptcy case. The second thing that happens on the petition date is the creation of a pool of assets. This is a sort of, I suppose, a legal construct, but a pool of assets that's referred to under bankruptcy law as the estate, the creation of an estate. And on the petition date, the debtor becomes a kind of custodian for the estate, and the estate is, at least as the metaphor goes, the source or available to pay the claims of pre-petition creditors. So you have this injunction that protects the estate while the bankruptcy case is pending. Another basic concept involves terminology. The word bankruptcy has a lot of connotations. People associate it with, the cartoon character wearing the barrel with his pockets turned out, kind of an assetless state of affairs, utterly bereft and insolvent. Debtor doesn't have to be insolvent to file for bankruptcy. Indeed, the Catholic organizations that have filed for bankruptcy may or may not have been insolvent, but it's really not important for purposes of access to relief. There are two pathways. Once you file for bankruptcy, there's two pathways to solve your debt problem. And the first one is liquidation. And the second one is reorganization. Liquidation is, of course, an attractive option, but not for Catholic organizations that, for canonical reasons, simply cannot liquidate. But when I say liquidation, what I mean is that the estate that's metaphorically created upon the petition date is collected and sold, with the assets generated by the sale of the estate used to pay down creditors' claims, pay off creditors' claims. So the estate, the value of the property, provides the solution to the debt problem. That's pathway number one. Pathway number two is reorganization, a case under Chapter 11 of Title 11 of the U.S. Code. And in that pathway, the solution to debt problem is typically not liquidation, but rather a negotiated, multi-party negotiated solution where creditors and other parties all agree on what's known as a plan of reorganization, where creditors will have their claims paid out of the kind of going concern operational value of the debtor, but subject to the same types of protections that they'd be entitled to if that estate were hypothetically to be liquidated. So although Chapter 11 is its own pathway, creditors are built into Title 11 entitled to a kind of baseline treatment that reflects how they would have been treated if this particular estate was hypothetically going to be liquidated in a Chapter 7 case. All right, so what's it like to be in a bankruptcy case? I think there are people who are participating today who can answer that, not as I do as a scholar, but because they've got the lived experience. But a couple of key points that I'll make about that: why life as a debtor in bankruptcy is different than life not as a debtor in bankruptcy. First has to do with information and disclosure. Once you seek relief in a bankruptcy case, you become obligated to provide a huge amount of information for the benefit of your creditors about your financial operations. You need to provide lists of your creditors. You need to provide information about how your property is titled, who else might have claims and interests in your property. You need to make disclosure about your cash management systems, your insurance environment. Huge amounts of information that's otherwise private and proprietary now becomes subject to compelled disclosure. So that's number one, and that's a big one. Number two, when in thinking about claims, let's talk about sex abuse claims. Outside of bankruptcy, each individual claimant is kind of like a lone ranger, a cowboy pursuing his own agenda. Once the debtor files for bankruptcy, claims are treated more in a more collective fashion. And bankruptcy imposes a sharing norm on all creditors who are similarly situated, or treated as claimants in the same class. And in a Chapter 11 bankruptcy case, sex abuse claimants typically are organized into an official committee where instead of kind of each speaking with their own voice, the committee speaks collectively for the benefit of all of those similarly situated claimants. So you move from an individualized norm to a collective norm. And I think that's an important distinction to note. Once you're a debtor in bankruptcy, professional fees, the costs associated with your own representation in the bankruptcy case, and in the costs incurred by other parties and interests, for example, the official committee of sex abuse claimants, all of those professional fee relationships are subject to disclosure and the supervision of the bankruptcy court. It's a way of, bankruptcy provides a way of managing professional fees, which can, which can be overwhelming outside of bankruptcy. It certainly doesn't eliminate those fees, but it just provides a court supervised process in which those fees are subject to scrutiny and management. Last thing I wanted to mention is the claims process. What happens to sex abuse claims in a diocesan bankruptcy case? Well, I mentioned that abuse claimants are treated in a collective way. They're typically represented by a single committee. In a bankruptcy case, the claims are going to be administered in a way that maybe a crude way of describing it is they're batch processed as opposed to individually litigated, or at least pursued in an individual way outside of bankruptcy. So all claimants are asked to complete a proof of claim form, which doesn't require a lawyer to complete. Asks for some simple information about the nature of their claim and some of the facts on which they rely. The bankruptcy court will impose what's known as a bar date, meaning all claims against this particular debtor have to be submitted via a proof of claim form before the bar date, or forever hold your peace. The bar date means that claims that existed in that pre-petition period but didn't get asserted, it's just going to be too late for those. And that, of course, applies and is effective. The bar date is effective, even if the state subsequently enacts revival legislation. For example, that's state law, and the effect of the bar date is federal law. And as I mentioned earlier, applying that conflict supremacy, federal law is going to trump even claims revival legislation. Just a fact on this, looking at cases since 2017, about 11 Catholic diocesan cases since 2017, the bar dates have ranged from between 54 to 191 days following the petition date, which gives you a kind of a rough idea of how long that claims accumulation process lasts in a bankruptcy case. Once all the proof of claim forms are in, as part of the terms of the plan of reorganization, negotiated plan of reorganization, one of the negotiated terms of that will be a claims administration protocol. Typically, the plans have provided for the appointment of a, names vary, but an abuse claims administrator, an independent evaluator of the information provided on proof of claims forms, who determines how much each particular claimant is going to be entitled to receive from the fund established by the plan of reorganization. And the plans so far have used an evaluation system, which I find to be quite interesting as a lawyer, because it really has very little, sort of loosely connected with the way those claims would be litigated outside of a bankruptcy case. There's the points factor, there's plus points based on the nature of the abuse, the type of abuser, the impact of the abuse on the person, and minus points. If the abuser was, for example, not a diocesan priest, you lose points that way. And then at the end of the game, once the size of the pot is established, all of those claimants will receive a check based on the kind of par value of the number of points that they have relative to the size of the pie. It's a very pragmatic way of administering claims, in contrast to the usual kind of litigated court proceedings subject to the rules of evidence, which kind of yield a very different result. Plans of reorganization, that I'm going to just touch on this briefly. Plans of reorganization that have been achieved so far have all been by consent, by agreement of the parties. There is a process in a bankruptcy case, and perhaps Archbishop Hebda will talk about this later, because it nearly came to that in the Minneapolis St. Paul case with which he's familiar. There's a process to cram down a plan, confirm a plan by what we call cram down, even though all the creditors and parties in interest don't consent. But we haven't seen that happen in any of the Catholic organizational cases so far. Well, I know I've left a lot of questions unanswered, and there's a lot more to talk about, but I'm going to wind up my remarks to make sure that we have time for our other speakers. And again, I want to welcome everybody to contact me outside of this meeting, or later on in our question and answer session, and I'll try to answer what's on your mind.